you were well organised with the water. They started off giving out water.
Yeah.
And then they stopped. They had a change of policy, probably because of the cost. Last week. So you've even got glasses.
Yeah.
You sure you've got champagne left there? Sorry. Picnic basket.
Application and appeal in the matter of Armstrong and another and Berrymans Lace Mawer and another.
Yes, Mr Lynch.
Excuse me. May it please the court, I appear with my learned junior, Miss Natalie Cove, the appellant Travellers, and my learned friend, Mr Christopher Boardman QC, appears for the joint administrators, my learned friend, Mr Ben Hubble, for BLM.
Yes. Now, before you start, if I can deal with a couple of matters of housekeeping before you deal with any housekeeping, if I can tell you, we've all had the opportunity of doing considerable amount of reading. So you can take it that we've read the judgments, got an argument, looked into the authorities. There's the the supplementary skeleton argument, which is in dispute. Respondents' additional documents, unagreed respondents' bundle in dispute, and I think some respondents' authorities are in dispute. Can I tell you that we've had an opportunity of discussing that, and we've had a look at each of those, and we take the view that we're going to admit them all and work on the basis that if they're of any interest, then we'll be taken to them, and if they're not, we'll ignore them. I don't think there's anything to be gained by having a mini dispute about that. The other thing is that having done substantial reading, I noticed that this is listed for a day stroke a day plus. We're confident this matter can be dealt with in a day, and I would anticipate that you would all agree with that.
My lady, I'm grateful. In fact, my learned friend and I, in the space of 2 or 3 minutes, in person, managed to reach agreement, in fact, on all of the points that my lady has kindly already addressed. I'm afraid it's sometimes a facet of remote working that makes life more difficult.
Well, I don't know about all of you, but I can certainly say on behalf of us, we're just delighted to be back and delighted that that people are willing to come back. And I know that in some areas people seem very resistant, but for our part, we're absolutely confident that the litigants get a much better quality of hearing. Satisfactory, it can be done remotely, but it's undoubtedly more satisfactory for all concerned. And it must be for all of you trying to agree matters and sort things out.
My lady, absolutely. I hope it's not inappropriate, I'm sure I speak on behalf of all of us, to echo my lady's comments.
Well, certainly.
And gratitude.
Certainly, we find having to have some sort of parallel universe where we try and talk to each other instead of popping out all very difficult is not straightforward. Now,
my lady, I'm grateful. Well, I'm extremely grateful for the pre-reading that the court has kindly undertaken. I recognise how difficult that must be, particularly in the modern day, to spare that amount of time. I was proposing to go through some of the background to the PIP case,
yes,
and the various files, and then some of the background to the application. Given the pre-reading that the court has done, I will just take that extremely quickly.
I think you can. I don't, please emphasise anything that you think is of particular relevance for when you elaborate your arguments. But yes, we have got a pretty good grasp of it.
My lady, absolutely.
I even drew myself a little chart.
My lady, I'm extremely grateful. Well, if I could go then straight, please, to the assignment itself, yes, in the core bundle, behind tab 7, please. And
sorry, I moved it into my own running bundle. Yes, thank you.
I'm grateful. And obviously the court will have seen it's an assignment between Transform, acting by its joint administrators, and HJI, Hugh James Invo Legal. There's some of the background set out on the bottom of that page. We then go on to page 116, where we see the key agreement at clause 1, and then over the page 117 we see that HJI are to instruct Hugh James. And obviously this is dated 30th of August 18. And I'll obviously come back to deal with this in detail, but just briefly in terms of some of the points of background that I was going to draw out. Obviously the court will have seen that the background involves the PIP breast implant litigation and the GLO. It's worth emphasising what that case was about. Obviously defective breast implants, or allegedly defective. There were huge variety of issues. Factual issues, witness issues, expert issues, issues about bringing claims against third parties, etc., as one would expect. So the three categories of files are the transform retainer files, which is only transform, the Travelers retainer file, obviously only Travelers, and the joint retainer file. Just to make an obvious point, the joint retainer file covers everything, covers all of the advice, privileged material, and obviously will contain non-privileged material as well that's been deployed, correspondence, etc., etc.
And subcontracting the sifting to Milnes Reeve.
And there's been sifting done, but to be clear, what the files contain is everything, right from advice about, obviously without waiving privilege in any way, but advice on liability, quantum, jurisdiction, third-party claims, etc., etc. The claim now brought by HJI is very narrow. It's on one issue. It is on the point about allegedly negligent advice given about disclosing Transform's insurance position. So that's all of the material about should we get this expert and advise on this point about defective quality, and there was was called a Russian roulette argument about, well, some of the implants were defective, some weren't, but everyone took a risk. All of those points just completely irrelevant to...
Well, that may depend. I mean, one never knows whether a document's going to be relevant until it's looked at.
Oh, absolutely. And just cutting ahead to a point which I'll come back to, but just jumping ahead to that, a way of dealing with that point would be for the administrators who are allowed to see the files, and Travelers always obviously said they're allowed to see the files, to pull out what they think is relevant and say, if it came to it and if the court were against Travelers on this appeal, at the end of the day, a way through to minimise the handing over of privileged material would be for the files to be gone through to pull out what's relevant to the very narrow issue.
But picking up my lord's point, the administrators are, there may be lawyers amongst them, but they're not lawyers conducting litigation. They may not be able to spot the relevant document.
Absolutely, but they do have their own lawyers who've been involved throughout. So, and in fact, Mr. Reddy is here, and it would be his firm who could do that. But that's a point I'll come on to at the very end, because it's a sort of final alternative. Okay. But anyway, I just wanted to make that point now because I'm obviously hopping through a lot of the background I would have gone through. So cutting to the chase on that.
And on the claim, and I quite understand that it's one issue. Speaking entirely for myself, I was assisted by seeing the pleading because I couldn't quite, in my own head, work out precisely how it might be put. But I was assisted by looking at the pleading, which actually is in the respondent's unagreed appeal bundle. But it sets out what the claim is, and as I understand it, that is the claim which Judge Jarman did not strike out.
Yes, that's exactly right. And a point I'll come on to is that if privilege travels at all, and obviously we'll be going through that in some detail, but if privilege travels at all, it only travels to the extent of the transfer. And the extent of the transfer here is a cause of action. And it's only documents, privileged material relevant to that would transfer. But again, that's an alternative that I will come on to much further down the track, if that's... sorry, just in terms of timing, I recognise the court's indication, and I'm grateful for that. If I were to finish by, I don't know,
well, I think it's Mr. Boardman you need to consult rather than me, Mr. Hubble. I think Mr. Hubble's more of a watching brief, but Mr. Boardman and you, perhaps you just want to just whisper together for a moment and just agree the time between yourselves.
My lady, I'm grateful.
No.
My lady, I'm grateful. So we've broadly got a plan.
Good. Thank you.
I'm grateful. So if we go back to the assignment, please.
Yes.
Page 116. And we see what's assigned are the claim, shows an action and rights whatsoever transform may have against potential defendants arising out of or concerning the conduct of defence by the potential defendants, etc. And we now know what that cause of action is. And as my Lord, Lord Justice Coulson rightly pointed out, excuse me, that's in the particular claim. So that's the transfer. And I've said a point I'll come on to make is that what is relevant is the scope of the transfer. We then see separate, clause 1.2, agree to provide Inver Legal with reasonable access to any and all documentation which is in administrator's possession and control which relates to transform, defence and litigation to include privileged documentation. So we have an assignment and then a contractual agreement. We've seen clause 2 over the page on page 117 about Hugh James acting. And then just to skip through it very quickly, just to show the court that that's convenient, we see clause 3 on indemnity, Inver Legal's obligations. We then see the signature pages. We see it's signed on page 121 by Mr. Locke of Inver Legal, but obviously of Hugh James as well. Page 122 is a long list of the claimants, who are the same claimants, in fact, who appeared in the long list behind page 123 to 125. That's the order of summary judgment. So 125 is the same long list being removed. Declaration of trust, that's the how the money is to be dealt with and handed out. And then page 130, client agreement. And so as Travellers understood this was a client agreement where the clients would be clients of Inver Legal, because we see at 132, it is hereby agreed that in consideration of Inver Legal agreeing that Z should be one of the claimants of beneficiaries, etc., she will not claim or seek to claim the administration of transform for the sum due under judgment, including interest or any part thereof, any further costs. So that's the assignment. What I was going to do was to...
That makes clear, doesn't it? Satisfy her judgment in full, including costs, common costs, further common costs, VAT, disbursement, AT, premiums, and so on. This is all about costs.
It's all about costs.
This is all about the costs that were not recovered when the claim against Transform was settled.
In essentially, yes.
Because a whole load of the original claimants were not covered by the Travelers Insurance.
Yes, exactly.
As a result of which there was a hole, potentially big hole, in the costs recovery.
Yes.
That cost recovery was the subject of the Section 51 application, which ultimately failed in front of the Supreme Court, although it had been successful until then. And so these are the costs that people are looking to fill. This is the costs gap.
Yes.
And that's ultimately what this case is all about.
Exactly. And so I mean, I assume, but I don't know, that the claimant's representatives will have agreed with the claimant something along the lines of, well, we will only pursue you for cost to the extent that we can recover from others, or something. So that would get around a problem with the...
Because what it isn't is that the unfortunate claimants who had claims that weren't covered by the Travelers Insurance, they may have claims against the solicitors and counsel in negligence, but they can't be compensated for anything that went wrong in relation to the silicone implants, because obviously that was nothing to do with the solicitors and counsel.
Yes.
Which is why it must be about cost.
Exactly. And that, in fact, that's made clear in one of the administrator's reports where the figures are clear on that front. But so that is right. That's what this is about. And the court may well have seen in the news that, in fact, a remarkable timing in the way that life sometimes, fortunately, must be a huge relief, frankly, and is fantastic news. I don't know the judgment, so I can't go into any details.
That was against the German company.
Exact, TUV Rhineland.
Because I'm assuming that the French company have gone under.
PIP went under, and
this is a claim against the German company, which was great news, although I saw that they were suggesting they would appeal.
I had not seen that, but I have to say that doesn't surprise me at all, but hopefully that will continue with a victory. This is exact, and my Lord puts it exactly right, and I'm grateful. I was then going to go into the background to the application. The court will be aware of travellers' unhappiness. I do not need to labour that, but this is a fundamental right. It's a fundamental right to privilege. We're not talking about an inconvenience. We're not talking about some minor issue. It is travellers' fundamental right to privilege. And the facts speak for themselves on that front. They're summarised in our skeleton argument. They're addressed in the judgment. It is very unfortunate the way that it was conducted from travellers' perspective. I'm not going to go behind the findings of fact made by the judge, obviously, but what was surprising, as the judge found, was that nobody thought to tell travellers any of this. There's an assignment. Your privileged documents are going to your direct opponent in litigation on the GLO and the Supreme Court. When travellers raised it, the response wasn't, oh, sorry, we failed to tell you. Actually, they are going to Hugh James, ultimately. It was just not mentioned again. And it was only because travellers eventually said, well, look, we do need protection by undertakings. And the undertakings said, you can't give them to Hugh James, assuming that that was what everyone was agreeing, that eventually it was flushed out that they were going to Hugh James. And so that is a remarkable position when we're talking about a fundamental right. And I'll come on to the authorities on that in a moment, but that's why travellers were so concerned. But I won't take the court to those documents now, because I think, really, I hope that point's clear. If we do need to, obviously we can laboriously go through the unfortunate events, but hopefully that won't become necessary.
But those, I'm so
Sorry,
sorry.
no.
But those events, in any event, don't impinge on the legal analysis, do they?
They do to one extent, which is that they go to the point about fundamental right. Because the court has to be aware all of these cases turn on their own facts. And how the other side has acted is very important in terms of understanding, well, where do the risks lie? What's at issue? And what's at issue is a client, one of the clients, travellers, which is entitled to assert privilege with giving no reasons. And I'll come on to the authorities on that. But there's a really good reason behind their concern, which is travellers at first said, fine, have the documents. They're going to an entity that we've got no particular concerns about, although slightly odd. They're going to HJI. They had a later concern. It's right in terms of how that affects the legal principles. The principles are just the principles. But the application is something else. So that is why I make the point. But again, I won't go through the documents again because it would just take too long, and I'm very grateful for the indication of the reading that's been done already. What the upshot of that means is that we have the essence of this issue, where the idea is that there's a joint retainer, A and B, of solicitors. B wants to hand over the documents to C by an assignment. The reality is that we've got to go from common ground, which is it's common ground between the parties that both Transform and Travellers can see the joint retainer files, but neither can disclose to another without the other's consent. So that's common ground. The oddity, though, is that if the joint administrators are right, that same effect, the reality of that same effect, can be achieved by an assignment, because that is what will happen. The documents will physically go to someone that Travellers would otherwise be able to say, no, well, no, you can't. And that's the oddity behind this.
Isn't that, setting aside for a moment Travellers' dismay for all the reasons you've given and we've read about, surely that's the position on any assignment.
When there's joint privilege, we're obviously dealing only with joint privilege. Exactly. So whether there are good reasons, bad reasons, no reasons, that's absolutely right. And a client is entitled to say, it's my privilege. I'm afraid that is a fundamental right and I don't waive it. Where we have an assignment, then the effect will be to hand over those documents to a third party. So what I'd like to do is really cover 4 points. And so that rattling through would essentially cover the background. And Travellers makes the following submissions and outlines. So first point, the most helpful authority and approach is the Winterthur decision. Second point, the scope of the successor and title principle is delimited by the title which is transferred and the nature of the transfer, and it should not be understood as an unrestrained principle by which any and all privilege attaches to and is transferred with title. Third, when considering the question of whether the successor and title principle applies to joint privilege, the court should not take in re Königsberg, surface technology or twin benefits as good or helpful authority. And fourth, essentially when taking the question of whether successor and title principle applies to joint privilege, the court is not assisted by in re Königsberg, surface technology or twin benefits. Fourth, applying those authorities to the facts of the present case, it's submitted that the assignment does not make HJI a successor in title in the sense that this prevents Travellers from asserting its privilege over the joint retainer files and withholding disclosure to HJI of the jointly privileged document. So that's really taking the principles, apply them to the facts, that's the submitted outcome. But just before addressing those points, if I could please make 3 preliminary points. The first one is to turn up Schlossberg, please. And now I think we're very largely going to remain within the authorities for a while. And so if it's convenient to the court, if I could invite the court to take up the bundle of authorities. And the first is Schlossberg, please, and that's behind tab 9. I'm sure I'm mispronouncing Schlossberg, but I hope that's it's not too bad. If I could invite the court, please, to turn to page 230 of the bundle. And I'd like to refer to paragraphs 44 and 46 to make the point that the Traveller's fundamental right to privilege is a rule of substantive law which, as established by authorities, should be jealously protected. And abrogation by statute, for example, can only be by express statement or necessary implication. So paragraph 44, the history of the principle is examined in detail by Lord Taylor of Gosforth in R and Derby Magistrates, ... in his speech, he described privilege as a fundamental condition on which the administration of justice as a whole rests. Acknowledge it is a fundamental human right protected by the Convention of Protection of Human Rights and Fundamental Freedoms. And then at 46, R. and Morgan Grenfell, Lord Hoffman, with whom the other members of the Appellate Committee of the House agreed, said that it was common ground that legal professional privilege is a fundamental right long established in the common law and a necessary corollary of the right of any person to obtain skilled advice about law. He said it cannot be effectively attained unless the client is able to put all the facts before the advisor without fear they may afterwards be disclosed and used to his prejudice. And there, for the court's reference, Travelers Skeleton Argument, paragraphs 26 to 30, Leeds and Lemos, same bundle, tab 7, page 165, at paragraphs 278 to 280. But there's no dispute about these principles. Second, it's important to be clear about what the joint administrators are asking the court to do. The joint administrators say, well, it's just the application of the successor and title principle. There you go. But the actual reality is that it is the same effect as abrogating traveller's privilege. And we see that again in Schlossberg, please, at paragraph 50, so 50 on page 231. So we see here, this is my Lord Sir Terence Etherton, Master of the Rolls, at paragraph 50, referring to the judge, Mr. Justice Arnold, at 50, saying the judge said that he did not consider the principles stated by the House of Lords in the Morgan Grenfell case are directly applicable in the present case. I infer from paragraph 66 that was because he took the view that the case about whether privilege in documents had been transferred to the trustees rather than about its abrogation. I do not agree with that analysis. From Mr. Schlossberg's perspective, the only question is whether or not the effect of the statutory bankruptcy code is that he has involuntarily been deprived of his fundamental rights of certain privilege in the information contained in the document. See no reason why the principles in Derby Magistrates, the Sims case, Morgan Grenfell case should not apply in answering that question. So, from Traveller's perspective, it's the same thing. It's about abrogation of privilege and abrogation, therefore, of a fundamental right. Finally, again within Schlossberg, the third introductory point, if we look at paragraph 40, please, 40, on page 229, we see here the issue at the heart of this application and appeal concerns the interrelationship between two public interest policies. The public interest that the trustees of bankrupt are able to get in, realise and distribute the bankrupt's estate in accordance with the Statutory Scheme 1986 Act, and the public interest that the person is able to consult their lawyer in confidence in the knowledge that what is told to the lawyer will never be revealed without their consent. And it's not dissimilar here. It's two competing principles and two competing policies. One is, well, there's a successor entitled principle, and that would benefit the administrators because they've sold a cause of action, to put it in simple terms. But that's got to be balanced against the fundamental right that Travellers has. Now, that balance, we'll come on to see, was analysed by my Lord Sir Terence Etherton, MR, in Schlossberg, and the balance was plainly found in favour of defending the fundamental right. And that's what Travellers would submit is the right answer here as well. And I'll come back to that point when we come on to that authority. It's just worth making one other introductory point in support of that, which is tab 7 at page 146, please. So this is part way through the judgment of Judge Hodge QC in the In Re Lemos case. It's paragraph 141. It's a reference to the same point made in the Court of Appeal in the Schlossberg case. And just to underline the point, however great that is, does not justify even a limited exception to the absolute nature of privilege. There is no balancing of interests. So it's not a question of thinking, well, wouldn't it be beneficial for them to have the documents and then balance those? It just isn't a balance. It's a fundamental right, and that has that effect. So if I could now move, having dealt with those three introductory points, onto Traveller's first point. So the point that the most helpful authority is the Winster decision. We do need to look at Winster in some detail. I hope that's convenient. It's behind tab 11, please. And I recognise that the court will have pre-read the judgments, the skeleton arguments, and everyone's been saying a lot about the judgment. I hope what I do will help, which will be to run through the judgment, obviously at some speed, but it is obviously of importance. So if we start, please, just at the beginning on page 286, obviously the litigation concerned ATE legal expense insurance. NIG underwrote the ATE legal expenses insurance policies. NIG appointed TAG as its agent. And there was what was called a TAG scheme. And we see the scheme at paragraph 3 onwards. We don't need to go through it in detail. Just to point out that it is summarised at paragraph 3. It is just to make, hopefully accurately, a summary of this. There were 2 stages. The first stage was that essentially TAG and others would investigate claims. Were they good enough? If they were good enough, a claimant would be signed up, and that was the second stage. So there were documents in the first stage that were, as we come on to see, privileged to the insurer. There were documents in the second stage that were privileged to the claimants, which we'll come on to see, and it was found that there was common interest privilege in the second stage documents. So they're referred to as pre-ATE and post-ATE. So, and there's obviously a huge amount more detail behind it, but there you go. If we then go to paragraph 6, please, we see that Winterthur is involved as an assignee under 2 deeds of assignment. The first deed assigned causes of action, and the second, NIG's rights of access to information and documents relating to claims in respect to which AT policies were issued and on which indemnity has been paid. So 2 assignments. If we then please jump ahead to paragraph 39, we see so page 298, paragraph 39, we see the assignments. And first assignment we see at the bottom of page 298, NIG, going on to the top of 299, assigns absolutely to Winterthur all and any legal, equitable, or other interest shows an action country rights, etc., etc. And at 40, the further deed of assignment, which is to assign the rights to information and documents needed to efficiently investigate, prosecute, conduct actual potential cause of action described in clause 2.1. So those are the 2 assignments. If we then jump ahead to 40, sorry, so we've seen 40. So the arguments and outline, we have over the page at 300, the main arguments, paragraph 42. Mr. Holland said there are 2 categories, the pre-ATE and the post-ATE. And if we look at 44, we see that, so 43, sorry, Mr. Hollander submits either no privilege or privilege of the insurer, and it was found that that was the case. 44, Mr. Hollander submitted that there are several reasons why the TAG claimants can't claim privilege in the post-ATE documents, at least against the ATE insurer, NIG, and its assignee, Winterthur. We then see a summary of those arguments, paragraphs 45 to 47. Paragraph 45, there's a reference to the clause 6 in the NIG policy, and the court will have seen that that was in the insurance policy which permitted NIG access to documents under that wording. And then 47, the argument based on common interest and common interest privilege. So access that way. And there was a third argument about the client's careless of it.
Important point, isn't it? Because this is not a joint retainer privilege case.
This case,
Yes.
no.
Ours is. This is.
Yes, no. That's right, but it is to be treated as that because of the analysis of Mr. Justice Aikens as he was then in this case. So we come on to see
That I think that's a major point of difference between you. So you'll need to make your submissions about
yes.
you can allied the 2, because I think Mr. Bournemouth says we can't. So
Well,
we'll need to look at that. But anyway, you accept that on the face of it, Winterthur is about common interest privilege. It's certainly not joint retainer.
No, exactly. But we'll come on to see that Mr. Justice Aikens addresses it in a way, he draws a parallel between common interest privilege and joint privilege, which we'll come on to see. But to make an obvious point, there's no authority that addresses the issue before the court directly, because if there were, presumably we wouldn't be here. So this is the best.
You'd be amazed how often that is.
If only.
But we take your point.
My Lord, I'm grateful. We're doing the best we can in the circumstances with the authorities that we've got, and Traveller's submission is that this is the most helpful approach. So if we then please go ahead to paragraph 63, we just see the questions for analysis and decision, and there's a list there, which we don't need to go through, but I'm just skimming through the judgment to show the analysis. We then see what is legal professional privilege. We see that paragraph 65. We then jump ahead to paragraph 72, please. In what circumstance might a person be unable to exercise a right to assert legal professional privilege over communications otherwise covered by that right? And that's where we see at paragraph 72, 6 lines down, once privilege, always privilege. Moreover, if the client refuses to waive his right to maintain privilege for whatever reason or for none, that refusal cannot be questioned or investigated by the court. And that's the point we're in. We then see, jumping ahead to paragraph 92, please. This is a conclusion on the pre-ATE policy documents. The privilege was held by NIG, we see in the first 4 lines. And at the end of 93, we see that same point. That's just the answer on at that point. We then go ahead to 95, please. Are any post-ATE policy documents in the hands of panel solicitors referred to in the schedule to the panel solicitors outline argument subject to any form of legal professional privilege? If so, to what form? It was accepted that normal course litigation privilege would be a right belonging to the tag claimant. Is NIG entitled to rely on contractual agreements such as between the tag claimants and NIG? The latter is entitled to have access to communications. And that's the reference to the argument under conditions 4 and 6 of the NIG policy terms. It's really condition 6 is the relevant one. If we then jump ahead to paragraph 103, please, we see the condition 6. That's then analysed, paragraphs 104, 105, 107. And then conclusion at paragraph 111. On the basis of the claims, NIG or Winster, the claims entitled to bring to enforce rights and remedies from other parties on paying for case or loss under the AT policy. NIG has a contractual right under the AT policy demand tag claimant give it access to the relevant pre and post AT policy document. So that's the conclusion that NIG's contractual right must override right to litigation privilege. If we then jump ahead, please, to the bottom of page 320, assuming NIG is entitled to have access to documents in the hands of panel solicitors, is Winster entitled to see to the same access? And that's whether by contractual right or by assertion of common interest privilege of sword. Question first, paragraph 118, what is assigned by the assignments? So here we see, this is the analysis of the 2 assignments. And we see under the first deed, it shows an action, and at paragraph 118. And then at paragraph 120, we see that the assignment is rights of access to information and documents relating to claims. And in principle at paragraph 121, those contractual rights of access to information and documents will include those given to NIG under condition 6 of the ATE policy terms. So we then see paragraphs 124 to 126, the conclusion that the further assignment does take effect in assignment of rights of access to documents granted to NIG by the tag claimants under condition 6. And then importantly at 125, however, in my view it does not make sense to talk of NIG purporting to assign privilege or common interest privilege by virtue of either deed. legal professional privilege is not a right to conduct or prosecute cause of action against TAG, Rowe, Cohen, or panel solicitors, nor in my view is the right of access to documents or information arises under or connection with the ATE policy upon the proper construction of further deed. As indicated, in my view, the rights assigned are limited to contractual rights of access granted to NIG. They do not extend to any rights of privilege created by the law. If that analysis is correct, next question is whether in the present circumstances Winterthur is entitled to claim access to the pre- and or post-ATE policy documents as assignee under those two deeds. Mr Justice Aikins then addresses at paragraph 127 to 130 the position of Winterthur in relation to pre-ATE policy documents, so sole retainer. And here we see the position at 128. 127 addressed the position as if there were no privilege at all, but at 128 we see the position if they're subject to legal professional privilege. Mr Justice Aikins comes to the conclusion that it can be approached from two directions. First, NIG can waive its legal professional privilege in the documents, do so generally or for a specific purpose. And then secondly, if there's an assignment of cause of action in favour of Winterthur as assignee, then Winterthur stands in place of the assignor, ... Therefore, if NIG was entitled to claim legal professional privilege in relation to pre-ATE policy documents, then so can assignee Winterthur. So that's sole retainer. 132, position of Winterthur in relation to the post-ATE policy documents. It's really paragraphs 132 to 137. If I could invite the court may already have read those, rather than...
We'll reread them. We now have them in the context.
My lady, I'm grateful.
You would like us to read 132 through to all the sidelined portion?
Exactly. Well, to 137, 138 just sort of wraps it all up. But,
give us a moment then, please.
My lady, I'm grateful. I'm grateful. And so just to highlight a couple of points, at 133, we see at the end that if legal professional privilege is held jointly, then it cannot be waived by one person alone. In my view, the rule must apply equally to common interest privilege as much as to joint privilege, where, e.g., two parties jointly obtain advice from a lawyer. That was the parallel that I referred to between CIP and joint privilege. We then see at 134, Mr Justice Aikins accepting the submission of Miss Carr, she was then, that Winterthur must take the assignment of the cause of action with all its benefits and burdens, one of which is the post-ATE policy document subject to privilege common to the tag claimants. NIG's right to assert privilege not within the assignment of cause of action cover the first assignment, nor, as I've already stated, the right to assert common interest within the assignment of further deed. We then see the difficulties faced at 135, 2 difficulties. First, not obtained assignments, NIG's right to claim common interest privilege. Secondly, unless they waive, documents remain confidential as against all third parties. However, obviously there's condition 6. Condition 6 acts as a waiver. We see that at 136. And then 137, we see NIG has assigned the contractual right of access to post-AT documents. That has 2 consequences. First, it means that Winster can demand those documents as against tag claimant. Secondly, it also means that as between Winter and the tag claimant, the latter cannot enforce its common interest privilege that it would otherwise have had with NIG. And so that's a strong, Travellers would submit, a strong parallel with the present case, where we have an assignment, but there is pre-existing joint privilege. And so Travellers would submit that it is entitled to assert joint privilege against the world, other than against the other holder of the privilege, Transform. And so...
and Transform successors in title?
Not in the circumstances of this case. And the reason...
Sorry, just could you just tell me then, is what you're saying therefore that this, is it on the facts, this is an exception? Are you saying to the principle, which would be that ordinarily the successors in title would take on the same basis as Transform?
So 2 points. One, successor in title principle is subject to joint privilege. And so a successor in title can take title to the assignment, can take title to the cause of action, but the successor in title is subject to the joint privilege of Travellers, which is a fundamental right which Travellers is entitled to assert and say, no, that right to joint privilege does not transfer because Travellers does not consent. And there's a parallel with Winterthur. It's not direct, obviously. We have to look at Schlossberg, which is very helpful in this regard.
That's not a joint retainer case.
Well, Schlossberg addresses some joint retainer.
That's a case, isn't it, about the particular rules relating to trustee and bankruptcy?
Well, yes, it is, but we'll come on to see why, my lord, the Master...
Just noting down your answer to my lady's question, your first point is that you say, well, the successor in title is subject to Travellers' joint privilege.
Yes.
And you say that does not travel.
Yes.
Because Travellers don't want it to, effectively.
Exactly. Travellers is entitled to withhold consent.
Okay.
But
what was your second?
The second point is, all of these cases turn on their facts. The facts of this case are we have to look at the assignment. And the real question before the court isn't what in general terms is the answer. The real question before the court is what is the answer on the terms of this agreement. And so we need to go back, as I will, obviously, back to the agreement to see how it should be properly construed in the context of the authorities. And that's the answer on this case. On a different case... Sorry, I've seen my lady.
No. So I've misunderstood, because I thought your first point was a successor takes the cause of action, but it's subject to benefits and burdens, as Ms. Carr, she then was, said.
Yes.
So therefore it remains wrapped with the joint privilege issue.
Yes.
And you can't unwrap that issue. And I thought that was a general proposition that you're making.
Sorry.
But then the second point that you're making is let's look at the actual wording in this case, which seems to suggest that if the wording was different, the answer might be different.
Yes.
So I'm slightly confused.
No, and I apologise. That's absolutely, my lady puts it absolutely right. I put it wrong, I'm afraid. It's in the alternative. So in the alternative, we need to look at the agreement in this case. And sorry,
I'm sorry.
I'm afraid
I should have understood that.
No. I should have said it in the first place, I'm afraid, but I didn't. But I'm very grateful for my lady's question, because that does clarify what I should have said. So, and here, that's where we draw the distinctions between our case and Winterthur, where there was the condition 6 waiver point.
Yes. So the condition 6 point applies to your alternative argument.
My lord has it exactly, and I'm sorry. I'm afraid
That's fine.
I'm slightly rushing because obviously I want to stay within the day. So
No, but please don't rush to the extent that you feel that you're not able to put your case properly.
I'm very grateful. I'm sure I hope on a different day would have put it better. But today, thankfully,
You're doing fine.
I'm grateful to the court for the questions which make clear the points I'm trying to make.
It's all right, we ask questions anyway.
Well, I'm very grateful.
Yeah, you're stuck with that.
And sometimes they're, because of certainly speaking for myself, my own inadequacy. So please do continue.
My lady, I'm very grateful. We've seen Winterthur, and I think need to summarise the points that we've been through. It is worth saying that obviously what we've seen in paragraph 134 of Winterthur is that Winterthur must take the assignment with the burden of the tag claimant's common interest privilege. And that's plainly how Mr Justice Aikens considered the position in that case. And also we've seen the point about the parallel drawn between CIP and joint privilege at 133. So if we then go on to Traveller's second point, which is that the scope of the SIT principle is delimited by the title that is transferred. So this is of relevance in a number of respects, but in particular relevance to Traveller's alternative point. So Traveller submits, it's clear from the authorities the scope of the SIT principle is delimited by the title which is transferred and the nature of the transfer. It should not be understood as an unrestrained principle by which any and all privilege attaches to and is transferred with title. So if we go, and we just need probably one example, Crescent Farm. If we please look at AB 17. So Authorities Bundle, tab 17. No doubt the court will know this authority. Crescent Farm, purchasers and sub-purchasers were parties to conveyance of land 1959. Clause 4 provided within 20 years the sub-purchaser wanted to sell off any of the land, they had first to offer it to the purchasers at the price to be determined. Sub-purchasers then contracted to sell to a third party. Purchasers accepted the sub-purchaser's offer to resell. Sub-purchaser solicitors wrote they're taking counsel's opinion. Sub-purchaser's solicitors sent to the solicitor of the third party, among conveyancing documents, their instructions to counsel and an opinion by counsel. The sub-purchaser conveyed part of the land. Solicitors informed the purchaser's solicitors on the same date. In proceedings against the sub-purchasers and the third party alleging breach of contract, interference with contract, and conspiracy, the purchasers asked for production of the instructions to counsel and counsel's opinion. Third party contended the documents were privileged and related solely to matters of title, and that the successors in title are entitled to the same privileges. So we then see, please, if we jump ahead to page 390, just above G. Sorry, it's 390 of the bundle, sorry. And we see here, this is of course put an end to conditional contract, but not to the desire of the first offence to sell and of the second offence to buy. In these circumstances, the opinion of counsel was taken, and on March 18, 1966, first offence solicitor sent it to the second defendant's solicitor with a covering letter as follows. Further to our telephone conversation this afternoon, enclosed copies of the following are instructions to counsel, counsel's opinion, examined extract of the contract between Sterling officers, etc., ordnance survey map, conveyance, examined 1959 abstract. Thus, we've seen the instructions opinion was sent as part of the conveyancing documents. At the same time, or to be absolutely precise, the previous day, the first offence wrote a letter, and we see the correspondence. We then jump ahead, please, to page 393 of the bundle. we see the second defendants submit that these instructions of opinion were subject to legal professional privilege in the hands of the first defendants, which counsel for the plaintiffs was really constrained to admit, and which in any case, in my judgment, must be right. And the second defendants further submit that these documents are matters of title. The claim privilege is so made in their list of documents in these words. Such documents consist solely of professional communications of confidential character passed between the first named defendants' counsel for the purpose of obtaining legal advice in relation to the title to land now vested in this defendant. That is, second defendants, and finally say that their successors entitled to first defendants and such entitled to the same privileges. And we then see analysis at F onwards of the successor entitled principle. But the point that I refer to here is that it's the successor entitled to what? The privilege only attaches to whatever is, inverted commas, the title, the successor entitled. So it doesn't open the door to all privilege that is held by whoever the party is. It's only privilege relevant to whatever is that specific transfer. And so it's always coming back to, we'll look at the transfer. And we see that put pithily in the Leeds and Lemos decision at tab 7 in the same bundle. So tab 7, page 157. So this is tab 7, page 157, at paragraph 215. We see Judge Hodge QC saying, in my judgment, Arnold J. did consider the present farm principle applied in relation to assets documents. However, it's clear that there's some reservation about that principle. At paragraph 108, he said in this judgment, it was clear the present farm principle did not depend on acquisition by the successor entitled of property in the documents recorded in privilege information, but acquisition by the successor entitled of some other property to which the legal advice or litigation related. So it's always focusing in on, well, what actually is it that's being transferred? It's not a sort of open door to anything and everything. That's a helpful summary of that point. The next question then is, well, what is the transfer? What does it look like? What are its terms? And that's obviously determinative of lots of questions. A title to what? A title to property, cause of action. What, if anything, said about documents? Is there a waiver? Isn't there? Is there a condition 6 as per Winterthur, etc.? As to causes of action, it's obviously well established what is meant by a cause of action, and that's every fact which would be necessary for the claimant to prove in order to support his right to the judgment of the court. And what that means is that when applying successor entitled principle to assignments, the successor entitled enjoys principle over communications related to that cause of action, and more specifically, the facts which go into the assignee's bringing of the assigned claim. So what is the assigned claim? Subject to the terms of the transfer, always. And we have to see, therefore, and I'll come back to it, what are the terms of the transfer in this case. And we've seen, I don't think we'll need to turn it up, the Asplin case, which no doubt the court's well familiar with, for the court's note, paragraph 26, which is in Authorities Bundle 1 at page 12, where a right is conditional or qualified, its assignment does not allow the assignee to exercise the right without being subject to the conditions or qualifications in question.
Sorry, could you just tell me the paragraph
Sorry,
again? No, just so I can mark it.
Paragraph 26.
Thank you. Oh, it's highlighted. I'm sidelined,
So that was the Traveller's second point. Traveller's third point is to look really at Schlossberg, in fact, but that addresses In re Königsberg, surface technology, and then I'll come on separately to twin benefits. The short point is that In re Königsberg has been overruled and found to be wrong. And that means that the extent to which surface technology relies on in re Königsberg, which it does, is also overruled. The key point for present purposes isn't that it's been overruled, other than the fact it's obviously now a wrong decision. It's the basis on which it's done. And that's what's important. That's why we've got to look at Schlossberg again to understand why and the reasoning of the Master of the Rolls in that case. So the court will no doubt know the Schlossberg facts, but if I just summarise them perhaps briefly, if that's convenient.
Yes, thank you.
Mr. Schlossberg was a businessman and beneficial owner of WebInvest. Avonwick loaned WebInvest $100 million, which was guaranteed by Mr. Schlossberg. Avonwick subsequently commenced proceedings for repayment of sums due under the loan and guarantee. That was referred to as the Avonwick proceedings. Avonwick was represented in those proceedings by Deckert, and Mr. Schlossberg and WebInvest by Fladgate. Judgment was entered against WebInvest and Mr. Schlossberg. Neither WebInvest nor Mr. Schlossberg paid any sum in respect to the judgment. WebInvest entered liquidation, a bankruptcy order made against Mr. Schlossberg. As such, Avonwick became the principal creditor of both Schlossberg and WebInvest. Mr. Schlossberg's trustee in bankruptcy and WebInvest's liquidators then retained Deckert as their solicitors. Fladgates then provided the trustees in bankruptcy with 3 categories of documents pursuant to the exercise of trustees' powers under Section 111(1) of the 1986 Act. The documents relates to A, litigation in the county court regarding an attack on Mr. Schlossberg's cat. B, it's
Current climate about, litigation and changes in the law about pets, very significant.
Apparently,
Sounds like some sort of philosophical proposition, doesn't it? Schlossberg's cat.
It absolutely does, I think. B, statutory demands issued by Avonwick against Mr. Schlossberg and WebInvest subsequent applications to restrain Avonwick from petitioning for Mr. Schlossberg's bankruptcy and the winding up of WebInvest. And C, the Avonwick proceedings. Some of the documents in categories B and C were subject to the joint privilege of Mr. Schlossberg and WebInvest. The trustees then passed the documents to Deckert. Trustees wanted to permit Avonwick to make use of the documents for the purpose of claims in conspiracy which Avonwick had brought against Mr. Schlossberg. Mr. Schlossberg then issued an application against Avonwick, Deckert and the trustees for an order directing that Deckert cease acting as solicitors for Avonwick and the trustees on the basis that some of the information was privileged. Avonwick contended privilege in those documents now vests in the trustees. So that's how we get to the relatively similar issue to the present case.
Helpful, thank you.
Mr. Justice Arnold held the trustees acquired the benefit of Mr. Schlossberg's privilege in respect to category A, but not B and C. He held an injunction should be granted requiring Deckert to cease acting for Avonwick, as Mr. Schlossberg's rights in respect of privileged information would otherwise not be adequately protected. And on appeal, Master of the Rolls affirmed Mr. Justice Arnold's judgment and dismissed the appeal, finding that sections 283 and 436 of the 1986 Act do not treat privilege as the bankrupt's property, which is automatically vested in a trustee. A trustee could only use his powers in a way which did not amount to waiver of privilege, and Arnold J's order was therefore within the ambit of proper exercise of judicial discretion. So that's the case in a... But the key point here, please, if we turn to page 229, and the discussion and the competing policies. We've seen part of the reasoning already. So the Master of the Rolls sets out the competing policies and then goes on at 40, that's at paragraph 40. Then paragraphs 44 and 46, we see the
you've taken us to
the bits we've seen. We've also seen 50. Excuse me. We then jump ahead to 60, so 60, please, where we see a summary of In re Königsberg. And the perhaps if I just invite the court, please, to read paragraph 60.
Certainly.
I'm grateful. I'm grateful. We then see the conclusion at paragraph, excuse me, 63. I consider it clear that on proper interpretation of relevant provisions, 1986 Act, privilege is not property of bankrupt, which automatically vests in trustee in bankruptcy. Following Morgan, Grenfell, Sims case, bankrupt can only be deprived of privilege the 1986 Act expressly provides or as necessary implication of the express language of the provisions. And then 64, starting 5 lines down, neither Crescent Farm nor In re Collinsburg stand in the way of my conclusion. Crescent Farm case not an insolvency case, nor was a minute case, which was cited as precedent. The Crescent Farm case, they tell the particular facts. In re Königsberg was conceded by counsel that the privilege had devolved to the trustee in bankruptcy. And then this is the crucial point. More to the point, In re Königsberg predates the Derby Magistrates case, the Sims case, and the Morgan Grenfell case, which set out the proper approach. And so, unsurprisingly, Peter Gibson J did not apply the principles in those cases. Not correct on the point presently under consideration. And then we also see, again, we don't need to go through this in detail, paragraphs 70 and 71. Again, the references the Derby Magistrates, Sims case, Morgan Grenfell case, keeping focus on the status of privilege as a fundamental right. And so the analysis is that In re Königsberg is wrong, and so it is of little help today, just for that reason alone, because it's wrong. But much more importantly, In re Königsberg simply didn't consider, because it predated them, there's no criticism, it simply didn't consider the fundamental cases that go to the fundamental right, which are live before the court today. And so here, again, the court is faced, it's not the same, obviously, but it's a parallel. The court is faced with I see my law has...
You say live, but I don't think anybody disputes that privilege is a fundamental right. And in this case, it's a fundamental right owned by Transform on the one hand and Travellers on the other.
Yes, absolutely.
That's the issue.
Absolutely.
That's what we've got to grapple with. And so Königsberg's wrong on the bankruptcy point. It is also, Lord Etherton also makes the point that it doesn't reflect those later cases about the fundamental right. But I don't understand in this case that anybody says that the right to legal professional privilege is not a fundamental right. It's just, in this case, it's owned by two, not one.
Absolutely, and that my lord puts it absolutely right. That's the essence of it's not a dilemma, but that's the essence of the question.
Yeah.
Both Transform and Travellers have a fundamental right to what privilege actually is a right to refuse disclosure. That's what it is.
In the case where anyone's trying to undermine Derby and so on by suggesting there's any form of dilution of privilege, as my lord says.
No, that's absolutely right. But the key, it's the privilege has been summarised in B in Auckland District Law Society as the right to resist compulsory disclosure of information. So
without giving reasons.
Absolutely. But so both Transform and Travellers have that right. That is the core of the right. Now, they both have various other rights that go with it. But the essence of the right is to say no rather than yes. And so if it comes to, which it does in a sense, in this case, a question between saying, well, on the one hand, one holder of the right wants to pass on the documents to someone else and the other one doesn't, that goes to the essence again of what is privilege. And again, it's essentially to say no rather than yes. So
they can't say no to each other.
Can't say no to each other, but can... Sorry, my lord.
I mean, that they can't say no to each other, and that's where the successor entitled point comes in.
And that's absolutely right. That's why what this case does is go to that exact point where the joint administrator, are essentially saying, well, because they're a successor entitled, they're not a third party. But as a matter of practical reality, they obviously are. HJI is not Transform, and Hugh James is not Transform either. It is a passing over of sorry.
So I don't understand. Are you actually saying, therefore, in circumstances like this, it's not possible for there to be an assignment?
Oh, no, absolutely.
Or an effective assignment? That is the bottom line, isn't it?
No. Oh, sorry. Absolutely, I take my lady's point.
Yeah.
Or are you saying that an assignment, you can have an assignment, but it can't take privilege with it? Doesn't carry privilege, joint privilege?
Well,
Or the other person's joint privilege?
the first answer is to the traveller's first point, which is that as a matter of general principle, that is right, because unless travellers consent, that assignment is encumbered by travellers' fundamental right to joint privilege. But the alternative argument, which is an easy argument, frankly, on the fact of this case, is now what I'm about to do is turn to travellers' fourth point, which is we go back now and look at the actual assignment in the context of all the authorities we've been through. We now, please, if we turn back to page 6.
And we're looking at this because your alternative argument is on the assignment what? It wasn't assigned, or it was assigned with travellers with an overriding ability to object.
What was well, if we look, please, at 116, what's the argument? Yes, so the argument is there's an assignment of a cause of action, but as to rights to documents, there's an agreement. And so we see what is assigned is the cause of action. And as we've seen in the authority, we always have to come back to looking at the transfer and the wording of the transfer. And so here we see clause 1.1 is an assignment of all claims, shows and action and rights whatsoever its transform has or may have against potential defendants rising out of conduct of defence, etc. And 2 deals with issues of disclosure and privilege. That's the deal that's been done. Obviously, travellers had nothing to do with this. They had no input whatsoever. But 2 says the administrators hereby agree to provide Inverlegal with reasonable access to any and all documentation which, in the administrator's possession and control, relates to Transformers defence in litigation to include any privileged documentation. So there we see what has been agreed between the parties. And the first step is that the assignment is only an assignment as far as it's written in whatever the form of agreement is. And the assignment is of the cause of action, and the agreement is to the provision of documentation.
I assume that's right. What flows from that?
So what flows from that is that and this is at paragraphs really 53 to 56 of Traveller's Skeleton Argument. The assignment comes with whatever it comes with in the agreement. And the agreement says, well, we assign to cause of action, but in terms of provision of documents, this is what we agree. And that is simply a contractual agreement to provide documents, which does go on to say to include any privileged documentation, but it's common ground that a contractual agreement is subject to travellers' privilege. So that it's common ground and recorded in the judgment that neither party can disclose privileged documents to a third party.
Subject to travellers' privilege, whether it's a contractual agreement or an assignment.
Yes.
Nobody disputes travellers' right to privilege. It's the effect of it, consequences of that. Nobody's saying, because the waiver argument has gone, so nobody is saying that travellers don't have the right. I'm sure it's my fault. I can't quite work out where the point goes that the documents are dealt with in little 2.
Yep, sorry.
I mean, there may be an argument that the assignment, because it includes rights, may include the right to joint privilege in the documents. But I don't want to get into that if it's not actually relevant to anything. I'm just trying to work out where this point goes.
Yes, so what Travellers say is, so first of all, the assignment is claims, shows and action rights against potential defendants. So that would not encompass rights to privilege. What the parties have agreed is to say, we agree to give an assignment on whatever terms, but we also agree, this is the agreement, the terms of the transfer, this is where successor and title comes in. What are they successor to? Well, that is determined by the terms of the agreement. And the agreement says in terms that you've got an assignment of these causes of action. As it happens, we've now seen a particular claim, a cause of action. But on two, it's an agreement, it's an overriding agreement. It's saying we are, as contracting parties, agreeing this as to disclosure, as to documents. So one deals with cause of action, and two deals with documents. And that's up to them. They could have agreed anything, but they agreed here.
If they'd agreed something different, would the answer be different? If
Well,
there'd been an assignment of the documents, do you say that would have made a difference?
Well, it obviously depends on the facts. So we see in Winterton, there was an assignment.
Just let's concentrate on this case, because this isn't a point that is, as far as I can tell, in the judgment or in the grounds of appeal. What do you say the difference is? If two had been effectively an assignment as well, do you say that makes a difference to the outcome of this appeal?
So, Transform can only assign what it can assign, so whatever rights it has. If Transform had some overarching right to allow access to documents, for example, in the Winterton case, then they could have assigned that, yes, absolutely. But Transform didn't have any such rights. Transform's in the position of the insured rather than the insurer in, to take a parallel again, the Winterton case. So only the insurer had the benefit of condition 6. And I completely accept, had there been a pre-existing right that Transform could have assigned, they certainly could have assigned it. But they didn't, because they didn't have one. So what they have done is assign causes of action, but subject to their agreement as to disclosure of documents. And it's very clear. Agreed to provide inviolable reasonable access to any and all documentation, administrator's possession and control relates to Transform's defence and litigation to include any privileged documentation. And so the real question is, how does that fit with the assignment? And the answer is, well, the parties have answered it for the court. They've told the court, this is the bit that deals with disclosure. This is what the parties have agreed between themselves as to, if HJI says, well, look, I'd like to see this privileged file, the answer, according to the agreement between the parties, is, well, yes, you can under this contractual term, 1-2. But it's common ground that as to a contractual term, it's common ground, Travellers is entitled to say, well, we Travellers assert privilege. Because if there were just a contract between Transform and HJI to provide privileged documents, Travellers could immediately say no. And that, I mean, and that is common ground. So the answer on this case is much easier. It's a much narrower form of transfer. There's a specific transfer of the cause of action, and there's a specific provision dealing with the assignment. Sorry, with the access to documentation. And all of these cases necessarily turn on their own facts, on the specific circumstances and the specific terms of the transfer documents. We saw Crescent Farm, and we saw the summary in Lemos. Here, this is the document before the court, and that's on the facts of this case, the simple answer in the alternative to Travellers' primary case. Excuse me.
So the alternative argument is that this agreement means that Travellers can assert privilege against transformed successors in title?
Yes, as to the disclosure of documents, because disclosure of documents is dealt with
As
under...
to disclosure of documents to transformed successors in title.
Exactly.
They can't, you say this means they can't have it.
Yes, exactly. That's because of the agreement reached between those parties. And that is the nature of the agreement. If it were argued well...
It doesn't make any mention of what you're saying is a fundamental shift, because you're saying that this means, this agreement in 1.2 means that it's not a question of disclosure of documents to the world, but even to the successors in title under 1.1, Travellers can assert privilege.
Well, that's the term. So obviously, first step, does the successor of title principle, is it subject to joint privilege? First step. Second step, what is the title? What is the transfer? Here we see that 2 overrides 1. It's the agreement when the parties come to look at, well, what documents can we have, please? They look at 2, not 1, because that's the contractual agreement between those parties. And that's what they've agreed. It's always, all of these cases are going to turn on the specific terms of the transfer.
What I was groping for was why that meant that this agreement, 1 2, the first 3 lines, meant that the successors entitled to the assigned claims couldn't see the documents that the assignors could.
Well, and that's because of the terms of the agreement. They have
which bit of the term? I mean, it doesn't say that.
Well, they have the document has to be read as a whole. It's 1 is the assignment, and 2, administrators hereby agree to provide Invo Legal with reasonable access to any documentation in the possessions,
privileged documentation,
including privilege. And so when it's simply objectively construed, what does the impartial third-party observer make of this? If asked at the time of the contract, which provision deals with provision of documentation? Which, if one of the parties, if HJI said, well, actually, you know what, I'd like file Z, please. That is the only provision expressly dealing with that is 1.2. So 1.2 is the express term. As an express term, it overrides the general. And that's just a matter of, as Travellers would submit, the simple construction of this document, which is the document that we have to go to work out the answer in this case. So we don't need, Travellers doesn't need to go as far as the, in principle, the primary case, only as far as this specific term. And that's why, to answer my Lord's question, that's why 2 overrides 1. And it's not really, I'm putting that badly, I'm afraid.
I don't think it's overrides.
It's not overrides. I'm sorry, as I said, I've realised I was putting it badly. It's not that 2 overrides 1 at all. I'm sorry, I retract that badly worded phrase. They do different things. 2 is about disclosure of documents, and it's plain on its face. 1 is about the cause of action. When one comes to look at successor and title principle in terms of what privilege travels, one must always look at the documents that provide the inverted commas title. Here we have an assignment, and the assignment is only as good as the original rights and the agreement that sets out the assignment. Under the original rights, Transform has no right to override Travellers' privilege, as per Winterthur, for example. But as per the terms of the...
Travellers have no right to override Transform's privilege.
And
always a mirror.
My Lord's...
And that is the point.
Well, my Lord's absolutely right, but that is the point depending on the terms of the agreement.
And so, I'm sorry to leap in, I'm grappling with thoughts. So you're saying that little one is an assignment of what can be assigned, and that is the shows in action the claim. And at that stage, you're saying it's a subject, it's warts and all, it's benefits and burdens, it's miscar. And so at that stage, you still have joint privilege in the documents. You may have assigned your rights in relation to the claim, but that's subject to this joint privilege. But joint privilege means that neither party can say no to the other. And so the question still remains at that stage whether, if you can't say no, whether in fact that means that there is a fetter at that stage under little one. That's a difficult question. But what you're saying is it's only as good as little two because you can assign what you like. But if you haven't got the documents, it's not worth very much, in effect. And little two just says agree, and it says privileged documents. But like my Lord Justice Coulson, I don't see either whether we're under little one, that there is a limitation, or that the use of little two of agree and the reference to privileged documents, on the face of it, objectively construed, and makes it clear that there's actually some limitation that applies. Whereas I think you do. And so I'd just like you to help me about that. I'm sorry if I've been round the house to everybody.
No.
It's already been round, but I just need to set it out like that.
My lady, I'm extremely grateful. And that very, very fairly puts the point that's obviously an issue. The way that travellers would approach it is to say, yes, there's plainly an assignment under 1.1, and it's warts and all, and it's etc. And the difficult question about whether it's subject to joint privilege on its own. Mm-hmm. But whatever agreement was entered into, it is obviously only going to be addressed by its terms. And here we have an agreement that tells us the answer. It says, yes, you have your cause of action. Fine. And we agree under 2, because this is one of the holders of privilege agreeing with someone else what they're going to do. So this is transform, or through its joint administrators saying to a third party, HJI, here's our agreement. So when it comes to what is dealt with in terms of the provision of documents, they agree 1.2, agreement not assignment. Now we're I think clear under Winterter, certainly Mr Justice Aikens was clear under Winterter, it doesn't make any sense to talk about assignment of privilege. You don't, that doesn't mean anything. So it would have to be under the successor and title principle as a general rule that there would be a passing of privilege or not. But for, see Crescent Farm, see Lemos, see in fact a number of other authorities we haven't been to, always subject to the actual agreement. So when the successor and title principle goes over, as we saw in Crescent Farm, it was only privilege relevant to that transfer, as it happens that in that
and so that's the reference to conduct of the defence in little 1, line 3.
And on traveller submission, subject to 1.2, because again we're inevitably, because the successor and title principle only bites on the agreement, whatever rights are transferred and whatever the nature of the agreement is, those rights will always have to come back to being tied to what is the agreement. And here we have a contractual right, a form of title under 1.2 and an assignment under 1.1. And that's why when you're then saying, well, and that's why obviously been through Crescent Farm and other authorities, that's why when we're trying to work out, well, what are the limits on successor and title principle? Is it all of the documents in the file, even though completely irrelevant? Is it the right to transforms tax advice? Obviously not, but why? And the answer to why is always because we come back to the transfer itself. So that's why 2 is an immediate answer, because it is the transfer. It's one of the clauses in the transfer. And that's why 2 directly affects not just one, but the entire document put together. And so that's Traveller's submission on that alternative point.
And we've got it in your skeleton argument, 55 and...
My lady, I'm grateful. The next point is that if the court were not with Travellers on primary case or on the proper construction of this agreement, the next point is to look at 1.1. So what is 1.1? What is 1.1 assigning? And it's all claims, shows and action rights whatsoever which Transform has or may have against potential defendants. Now, my Lord Justice Coulson has drawn attention to the particulars of claim, and if I could go to that now, please. It's in the Respondents' Appeal Bundle, page 118.
Lucky we let it in then, isn't it?
My lady, I'm grateful, and I apologise for taking up the court's time with what turned out to be something that could be resolved between myself and my learned friend in a matter of minutes.
That's what you get in litigation about costs, in my experience.
Yes.
My lord, there's no stronger motivator.
Absolutely.
Absolutely.
Right, we're at the particulars of claim.
So we're now at the particulars of claim, and if I just set out the argument first, and then we...
Certainly.
So the argument is this. It's an assignment of a cause of action. At first, under the terms of the assignment, it's generic. Well, it doesn't specify what the cause of action is. We now know what it is. So that is, if within all the authorities we've been through, when one looks at what is the assignment, it is an assignment of this cause of action. So the question is, what are the privileged documents relevant to this cause of action, not all other privileged documents that are available, but this one.
Well,
So,
hang on. I just want to understand that. Is that a matter for the court? Because the issue which the judge had to decide was simply whether there should be disclosure of the joint retainer files to HJI and Hugh James. The judge wasn't asked to differentiate between X and Y documents.
my lord, the particular claim post-date the judgment.
Well, that may be, but the appeal is against the judge's order.
My lords,
And so you say, what are the privileged documents relevant to the claim? My speaking entirely for myself, my concern is that seems to be setting up an invite to differentiation between one type of document and another, which wasn't covered by the original order that asked the judge to decide simply the question of disclosure.
my lord is right, subject to 2 points. Obviously, the first point is that the particulars of claim post-dates the judgment. So we just are where we are. I'm afraid that's how it came out. I'm afraid.
Well, that may be.
But it's possible for litigation to go into stages. Runs up even more costs, but that's what happens. So stage 1 might be, is there disclosure? Then stage 2, which might be a different set of, or another set of proceedings or further hearings, which says, right, these are the list of documents that we think are relevant. And then there's an argument about, well, they don't relate to the cause of action relative to the particulars of claim, or you shouldn't be allowed to use those in any future litigation. But that's not for us, is it? Isn't that for something further down the line if your appeal is dismissed?
Well, my lady, the point of principle I'd respectfully submit is for this court, because the grounds of appeal say Traveller's primary case, and then the alternative case is that the judge misconstrued the assignment and misunderstood the what's transferred and the cause of action, etc. And therefore, if in principle the answer is, if this were the way that the answer went, yes, assignment, yes, transfer, yes, disclosure, but on principle limited to the cause of action because of the nature of the transfer, because of.
That still leads us into the next hearing when everyone falls out in lumps about whether or not a particular document is relevant. Or are you saying that it should be in the discretion of travellers to decide before disclosure?
No. So, sorry, if I'm not being clear. If the determination were, yes, there should be disclosure of material relevant to the cause of action transferred, because that's the law. I mean, it's clear that is the right approach. We have to look at what is the cause of action. Only privileged material relevant to the title, transfers, etc. If that's the answer, it's then for the parties to apply that, and hopefully the parties will then be able to agree. If the parties can't agree, then obviously, unfortunately, the parties would need to come back to court.
But that's what I was saying.
But and my lady's absolutely right. But the hope is that the sifting's already been done, and the documents have been given to the joint administrators. What would then the next stage would simply be for the joint administrators to say these categories of documents, i.e., relevant to this claim, are the ones we want. Fine. If that's the answer, obviously fine. And travellers always only wanted to do the right thing. It obviously agreed to disclosure in the first stage, it then agreed to disclose to HJI. They only want to protect their privilege. If the answer is, well, you can protect your privilege by narrowing it to what's relevant to this cause of action, then that's the next stage. It's simply, what that would then avoid is handing over advices about, again, without waiving privilege, but advices about cause of action against cloverleaf, advices about the expert evidence, advice about whether or not the products were defective, etc., because they're irrelevant. And properly applied, the authorities make clear that there is no transfer of privilege because that's not the title that's transferred.
But I do come back to my earlier and doubtless very glib assertion that it always depends on the documents. The difficulty is, I don't think it happens anymore, but I'm old enough to remember when I was first a barrister, I used to be sent off to firms of solicitors to sit in rooms surrounded by file after file of dusty paper to work through them, to work out sometimes what is or is not privileged, and sometimes to work out what is or is not relevant. And very often it did depend on the document, and you couldn't, it would be very nice just to have seen the title of the file and put it into one box or another, but you couldn't actually, you had to work through it, which was what made it so soul-destroying. But I think that is my concern. You say, well, something about the expert is irrelevant. Well, that may be right, may well be right, but I'd be a bit reluctant to decide that in a sort of incoherent way. That would be, speaking for myself, that would be my concern.
But my lord, I absolutely understand that concern, and I don't know if it's any consolation or not, but I have also spent that kind of time. And it has been,
I was going to say, we're now of an age where we think that's a jolly good thing.
Though I rather fear that you may be spending days and days and days looking at a screen instead of in said dusty office.
And in fact, that is.
I think I'd rather be in the dusting office, frankly.
In fact, that is in fact a point I was about to make, which is that we're talking about travellers' fundamental right to privilege. So where there are documents that are not appropriate to disclose, they really shouldn't go over. That's what travellers respectfully submit is the starting point.
Well, Mr. Lynch, you've heard our, as it were, threshold concerns about this. just want to go on and make whatever points you...
Oh, my lord,
want
absolutely, I
to.
understand. It's just, I was coming on to
Sorry,
say that...
that was my fault. I didn't think it was fair to allow you to embark on it without at least indicating my sort of threshold concern about what we may be getting into.
Yes, and just as a practical answer, everything is available on a database. Word searches can be done quickly, might be putting it a bit high, but it is well possible to run through this. It's all electronic, and it's well possible to filter things off one way, bring them in another way. Yes, it will take some time, but obviously the cost of that would then be a matter. It may be something that the court would indicate where the cost would lie if travellers did want to filter again. But the point of principle is before the court, which is what is the title, and that's what I come on to now on the particular claim. But just as a practical answer, in fact, whilst soul destroying, no doubt, in its own different way, actually it can be done online or electronically and quickly. So we see here the particular claim 118, and the way the claim is put, and we just zip through it, we've got the claimant, PIP, breast implant scandal, insurance available to transform. We then see paragraph 11, BLM instructed jointly by Travellers and Transform to advise. Then PIP breast implant litigation, BLM is retained by Transform in relation to claims not Travellers. But then importantly, paragraph 17, 17, page 123. We see on or about 22nd of February, Transform instructed BLM to act for it in the defence of such claims as might be brought against it in relation to which it would have no entitlement to indemnity from travellers' uninsured claims, such claims by the worried well or claims where any loss fell outside the period of insurance, the retainer. So the retainer that's referred to, and that's relevant, the relevant retainer for the purposes of the transferred cause of action under the assignment, is Transform's instruction to BLM. We then see a description of the GLO. We then jump ahead to, please, Hugh James' request for information about cover, page 130, instruction of Mr. Waite, page 132, and then please on to, bless you, page, 140, 140 at the bottom. And so duties owed by BLM, and on to page 141, paragraph 66, those implied by statute into the contract contained in the retainer, a duty on BLM to take reasonable skill and care in fulfilling its instructions to transform, like duty and tort, and then a description of the fiduciary duty about actual or potential conflict. And that fiduciary duty, page, paragraph 68, 69, is put on the basis of course, a duty to transform. It has to be, because that's the nature of the fiduciary duty. We then see similar points in relation to duty owed by Mr. Waite, paragraph 70, 71, fiduciary duty again to transform, and then 72, Mr. Waite owed Transform a duty at common law to take reasonable skill and care in formulating his advice. So the key here, and then we go on to paragraph 78, please. Breach of duty to take reasonable care and skill, which obviously necessarily are allegations of breach in respect of the retainer. And the retainer is Transform's retainer of BLM. And the fiduciary duties, as pleaded, necessarily refer to duties owed to Transform. Now, two things arise from that. One is, to the extent that there are documents relevant to that retainer, they are generally, or would generally, I haven't seen it, but one would imagine, generally in what's called the Transform file. and the court will recall there are 3 files, that's one of them. But what that means crucially for present purposes is that the cause of action that is assigned is this cause of action. It is about duties owed to transform the retainer, in inverted commas, paragraph 17, and fiduciary duty owed to transform. Now, that is the transfer, that is the assignment, that is the cause of action. The question for the court is then, based on that being the cause of action transferred, the title, in inverted commas, what privilege is relevant to that title? And so that's key step 1. Next step is, within that, what is the alleged cause of action? And my Lord Justice Coulson has already summarised this, and the court has the point. The cause of action is to say, well, it was negligent to fail to advise transform to disclose the insurance policy. Not, it was negligent to bring a claim against Cloverleaf, it was negligent not to bring a claim against another third party, it was negligent to admit liability or not admit, etc., etc. All of the other things that are in the ambit of what, without waiving privilege, would fall within the joint retainer file. It is only this. And so when the court comes to assess cases like Crescent Farm, Lemos, etc., what is the title that's passed? The cause of action, the title, the assigned rights are defined by what's pleaded, this claim, and what is pleaded is the retainer, in inverted commas, the fiduciary duty, and specifically within that, because that could cover lots of different alleged breaches, alleged cause of action, in fact, what it is the narrow point about advice on disclose or not the insurance policy. And that is the way the claim is put. We see that page 144, and it's slightly hard to get one's head around the claim in a way because it's so unusual, but there we are. But that is the essence of the claim.
And what do we get from that?
And my Lord, what does the court get from that?
Yes.
So
that is, as I understand it, the essence of the claim. But where does that go in terms of the issue before us?
Where that goes is, as we now go to the assignment, page 116. The assignment is all claims, shows and action, etc., may have against potential defendants, but we now know what that is. So what that gives to the court is the answer to the title transferred. That gives the court the answer to the privilege that travels with title, because all of the authorities are clear. Crescent Farm was clear. We saw some summary in Lemos as being clear. What one has to ask is, what is the title transferred? And with it, if the court's against Travellers, with it travels privilege relevant to that title. So the first question is, what's the cause of action? And the cause of action we've seen is limited by the retainer, fiduciary duty, and then the alleged breach. If it had named five other breaches, limitation...
That's the nature of the claim.
Yes, that's the nature of it.
So what?
So the so what is, that's the nature of the title.
Yeah.
And that determines the nature of the privilege that transfers. It's only privileged material relevant to title. It's not an umbrella. The door doesn't open with a transfer of title and a transfer, therefore, of privilege. The door is only as wide as the transfer.
Yeah.
And therefore, the answer is, when the court comes to determine, well, what is the nature of this transfer and the nature of the privilege that passes, it is limited by the ambit of the rights transferred. And
you're saying they shouldn't get anything, shouldn't be allowed to see anything, with your primary argument. But this is really a, in any event, argument.
This is a further alternative.
Yes.
This is, were the court...
In any event, they should only be allowed, you should be allowed to do a sift, if that was the outcome, if we were against you on the first two,
Yes.
you'd say all that should be disclosed
Yes.
is that documentation which relates specifically to Transform's claim as particularised.
Yes, exactly. And whether it's Travellers that does this, well, Travellers Lawyers that does the SIFT, or an independent party, Mills and Reeve, active BLM, or anybody else who does it, it doesn't vastly matter. And no doubt there would be an argument about costs, but that would be...
Oh, and who did it? And oh, there's scope for so much more argument.
But obviously, again, Travellers, I hope it's clear from Travellers' approach generally that the goal has been just to protect its privilege as far as it's allowed. And so when it thought it was just going to be handing over the files to the joint administrators, of course, Travellers immediately consented. But here...
I don't know how much... I mean, I understand that. Sorry to interrupt you, but just thinking out loud, I understand that. The practical difficulty is that what happened here is not uncommon, that the solicitors, BLM, are well-known insurers' solicitors. They would have been instructed by the insurers for all these claims. And then it would have become apparent that some of the claims weren't or might not have been covered by the insurers. And so the insured separately retained them. And if things go wrong, as it were, then it can be something of a logistical difficulty to try and work out what's in what file. But the what has happened here is not uncommon. I mean, I would be quite sure that would have been the sequence of events. So yes, of course, the claim is on a relatively narrow basis. And yes, I'm sure there will be documents in the joint retainer file that everybody will agree are completely irrelevant. But what we're talking about is privilege, not relevance, for the purposes of this appeal.
Well, my Lord, if I could just clarify one point in response to my Lord. Here, privilege and relevance are the same thing, because privilege only travels as far as it's relevant to the title. So if the court were against Travellers and said there was a cause of action transfer and this is the cause of action, and that is a necessary step. It's impossible to answer this question without working out what the transfer is. And here it's an assignment of a cause of action. What's the cause of action? That necessarily answers the next question, which is, if privilege travels at all, what privilege? Because it's not as simple as saying, I hope I'm being as clear as I can on this. It's impossible to say that there's a transfer of some kind without specifying, and then and therefore a transfer of privilege without specifying. The first step.
All of that ought to have been the subject of the original order. The order is one line. Should these documents be disclosed? And that's what you're going to get us to answer.
Well, my Lord, obviously, I've already made the point, and my Lord absolutely has the point. We just weren't no one was in a position to address what is the cause of action because the particular claim didn't exist. But we are now, and
I understand that, but we just have to be slightly careful about the wagons being drawn into ever decreasingly small circles.
My Lord's absolutely right. And a way with parties that will be able to take a sensible commercial approach to this would be if the answer were this to be the answer, in the judgment to be, well, that's the cause of action transferred. That determines the nature of the and ambit of the privilege that is transferred because it's a successor entitled to that privilege. There you go. And the parties would then read the judgment, understand it, and abide by the terms and ambit of that judgment, being sophisticated commercial entities that it's in their interest to try, as far as possible, to keep costs down and agree.
But you have to remember you've already been to the Supreme Court once.
My lady, absolutely is absolutely right. There's,
And you've just taken us to a document that your solicitors objected to going in.
but my lord,
This is cost litigation. None of you will ever agree about anything.
my lord,
I'm afraid that that as soon as you start reading the papers in this case, I'm afraid that's the first thing that occurs to you.
my lord,
So I do understand from a practical point of view what you're submitting, but you'll understand our scepticism.
my lord, that's absolutely understood. The reason for objecting, without going back into it, but the reason for objecting for the particular claim going in was historic and on a misunderstanding, which my learned friend and I cleared up in a matter
seconds, I should think.
Yeah, I'm sure.
straight. It's
But my lord's point is, I mean, had we been, this been some sort of a first instance hearing, which obviously it isn't, but listening to your submissions and you taking us to the particulars of claim, I don't know about my lady and my lord, but for my part, I'd have been said, would you like to go into the corridor and carry on this negotiation out there?
my lady, I'm very grateful for that indication. But the question, the question here.
It's not an indication. I'm just saying.
Oh no,
I mean, absolutely saying that seems to me, you know, you're in this dreadful, and I understand how it happens, but you're in this dreadful logjam where what perhaps coming to it fresh should have been sorted out between, as you put it, these sophisticated commercial entities months ago. It's just running up more and more costs.
Yes, and my lady's absolutely right, and I'm sorry, I didn't mean to misrepresent my lady's comment as a. The question necessarily for this court, though, is in the position we're in, which is the particular claim do now exist, and the authority is very clear. What is the right answer?
Well, can we just try and think about this from a boring procedural point of view for a moment? Because I think that is quite important. So
Yes.
We have the appeal that's in front of us. As my lord's reminded us all, the appeal is against the order that was made, which was the one-liner before a particulars of claim. So our primary task, our initial task, is to consider your appeal against that order as it was drafted with the information that was available at that time. Effectively, I think what you're submitting now is that there is significant relevant information now before the court in the form of the particulars of claim, which, had they been available to the judge, would have enabled the judge to apply a more specific and a more detailed order, which you say would have been to define the limits of the privilege by reference to the cause of action and therefore the title to the past. And so I think procedurally what you're therefore saying is, or inviting us to do, is to say, as we have all the powers under CPR 52 that the judge at first instance had, if we find against you on your primary argument, we should nevertheless consider substituting an order or allowing your appeal to the extent that to substitute an order defining the terms.
My lady, that's absolutely exactly what I was about to propose.
Is that what you're...
My lady, that's exactly right. And the proposal would just be by reference to the order that exists, which we see at page 43 of the bundle with the undertakings as exist, and simply inserting whatever appropriate wording were the decision to go in that way, narrowing the ambit in that way. And it would be simply a matter of
You know, I'm the last person to. My lord, my lady, will stop laughing in a moment at the idea of me getting into a procedural quagmire. But I mean, really, it's almost, isn't it, a Aladdin Marshall thing? Because you want to succeed on the appeal. So what you're actually saying is that the new evidence would have made a difference to the outcome, because the difference to the outcome would have been that the order that was made, if it should be made at all, should have defined the terms.
Yes, but the other than the procedural objection in the first place to putting in the particular claim, there's no debate about the particular claim.
No, I understood that. I'm just, what we have to do is, if, and obviously we haven't heard anything Mr Berrymans said about any of this yet, but if we felt it to be important and appropriate to try and give as much clarity as possible, not just for the purposes of your case, but for anyone else that finds themselves in this position, we've got to find a route by which we can legitimately do that.
Absolutely. I'm sorry, I misunderstood my lady's point. Absolutely. This fresh evidence is accepted by both parties, and to the extent that it's fresh evidence, it's fresh evidence, obviously, but it's obviously relevant. Neither party disputes the document itself,
No, I understand.
and neither party disputes its obvious relevance. But I mean, the administrators wanted in, and Travellers has accepted that. All I'd add is that obviously Travellers, albeit by streaming in some clever way, will have heard everything that's been said and will understand the court's points as to the approach that ought to be taken. And were this the outcome on this appeal, that there were a narrowing, it's not even narrowing, it's defining, that would be very helpful, and in fact would actually save costs significantly, because what doesn't help is a vast handing over of everything under the sun that's totally irrelevant, and that can be removed by a number of keyword searches, and so there's a huge advantage. Sorry.
No. I'm just thinking that perhaps I'm not as cynical, perhaps, as my Lord Justice Coulson or my Lady Justice King, although in some respects I am. But I wonder whether, having heard everything that you've said, over the short adjournment, you might discuss a narrowing or a definition in the way that you have been articulating on your feet, in order to see where that proposal might get you. That's all I say.
My lady, thank you.
Because you've now helpfully identified this, we've now effectively got three arguments. There's the principle.
Yes.
There's the alternative by reference to the facts, and in particular the assignment. And then this is the third point, which is if you're wrong about 1 and 2, you still say it would be helpful to have I think defining was my lady's term, which I understand. Echoing what my Lady Justice Asplin's just said, understanding, of course, that it's WP to your arguments 1 and 2, that might, if speaking for myself, I'd have thought her suggestion was a good one, simply because we want to be as helpful as we can without getting something wrong because we didn't have all of the relevant information because it hadn't been dealt with below. That's the tension.
My lord, absolutely, and I'm grateful for that explanation. I suppose the only point I'd add is it is really only just the particular claim. That's the only new document. So it just simply didn't exist at the time.
Well, I think we perfectly understand that, and so therefore we're not criticising the judge or the parties or anyone. It just,
my lady, I'm grateful. I've run out of time, I'm afraid. The only last point I was going to cover is Travellers' supplemental skeleton arguments. To
Well,
to
we've read that. I don't
which
think it's much anyway.
I have nothing to add to that other than to refer to the relevant authorities which are in the bundle. My lady, I'm grateful.
No, thank you very much indeed, Mr Lynch. Now, Mr Warren.
My ladies and lords, I think it may help if I just start with just a quick response on some of the early points that were raised with my learned friend about what this claim is and what the nature of the assignment is, if I may, before turning to what I understood to be the real nub of this appeal, which is a pure question of law, whether or not the successor entitled principal includes joint retainers as well as sole retainers. Now, my Lord Coulson is quite right to say that costs are a very important part of this claim. I think that there was a reference in some of the documents to the figure of about £11 million. That is absolutely right, although that is not the way the claim is pleaded. It includes costs, but it's not by any means the extent of the claim. Just to make that point good, could I just invite... I'm sorry, Mum?
Is it 17 million in the claim?
There's no figure on it as such. In fact, this was one of the issues that was dealt with in the application for summary judgment before Judge Jarman, namely whether or not the claim as pleaded had any real prospects of success in terms of what the claim was for. If I could just invite my ladies and lord to page 150 of the Respondents' bundle.
Yeah, the loss and damage.
Yes.
Yeah, I turned to that first.
Yeah.
As a construction lawyer, you always follow the money.
Yes, exactly.
And it's quite brief, isn't it?
It's very brief. It's very brief. And although it's now the subject of a lot of evidence and argument, and there's a judgment as well, which I could take ladies and lords to if necessary, but I don't think it is. I just make the point that there are two broad categories of claim. One is for, if you like, lost value of what the business was. Right. The company, Transform, would not have gone into administration, but would have continued trading. So that's a diminution, if you like, of the value of the business and the assets of the business claim. And then secondly, at B, Transform would not have had the judgments entered against it. That's not just the costs, but of course the principal as well. I believe that the principal of the judgments was around about the same figure that I mentioned. It might have been the 17 million figure that the lady mentioned a few moments ago. So
would not have had the judgments. That's the uninsured claimants.
Yes.
Judgments.
Yes. And there is a bit more meat, if you like,
I
on
slightly
this.
struggle with that. How could the lawyers be liable for the sums entered by way of judgment by the claimants against Transform?
Yes. That's the point I wanted to raise.
That seems to be a slightly magic
yes.
touch. How do you get from one?
Well, that was the subject of argument on the summary judgment application. Oh, right. The defendants essentially said, you can't make a claim for this because you always had this liability.
Yeah.
It can't be a loss that's suffered by any negligence in this case. Yeah. And the answer to that is, well, but for the negligence, that is to say, if there had been disclosure to the claimants would not have brought the claim. That's the point. Now, there is, under the heading causation, starting at the bottom of page 147 onwards, some further details. And there's two scenarios set out there on page 149, going over to 150. What would have happened if disclosure had been made? And essentially, for example, under the first scenario, so if I begin at page 149, paragraph 83, upon being informed of the limitations of Transformed insurance cover, the claimants would have reacted as follows. First scenario, either information provided before the register was closed, and paragraph 85, the steering committee would have formed the view that Transform couldn't satisfy any damages, and they wouldn't have joined the register. So in other words, the company would not have been facing these claims if disclosure had been given before the GLO had closed. And therefore, at paragraph 86, Transform would only have been facing the claims that were within the GA. And then...
it's not relevant
Yes.
to today, I don't quite understand.
Yes.
The potential logical fallacy of that is that they wouldn't have brought the claims because Transform weren't insured. Not that they wouldn't have brought the claims because the claims weren't valid. They simply wouldn't have brought the claims because Transform weren't insured.
That's the pleaded case.
Yeah, well, I understand that.
Yes.
I understand that.
And there may be issues
So
about... I can see why the point arose, Yes.
the debate on the striking out.
Yes.
But one of the things that we, for the purposes of this appeal, that we obviously have to work to, is that the claims in the particulars of claim are arguable, because they've not been struck out, and that must be an assumption that we must make.
Yes, my Lord, if I may respectfully agree with that.
Yeah.
And indeed, my ladies and lord do not have the full pleadings, and therefore don't see the whole picture of the issues in the case at the moment, because the only document we sought to put before the court was this one, just to show you that there are certain documents that have been used in that litigation. And
Well, speaking for myself, as I said at the outset, I found it very useful.
Yes.
As obviously Mr. Lynch now.
Well, surprising.
So well,
There we are.
It's just useful because it seems slightly unusual.
Yes.
If I may say, as a claim, it's the flesh on the bone that makes it live.
Well, and just on this point, my learned friend said that this information wasn't before the court below. It's quite right to say the particulars of the claim were not there, but as my learned friend pointed out in his skeleton argument, with some merit, in fact, there was the letter of claim, which refers to these documents that are referred to in the particulars of claim and sets out the claim as well. I can show...
The judge certainly operated on the basis that the point in issue was the alleged negligence in failing to disclose the insurance.
Absolutely, absolutely. We do have it, just for benefit of your notes, if you'd like to see it, in the bundle.
This is the letter of claim.
This is the letter of claim, which is at page 41. 41 to 51. Now, and just the last point on this is that, as I mentioned, obviously, theoretically, one of the issues that could arise, say theoretically, at least theoretically, because I have seen the pleadings, although I can't show you them, is whether or not these claims were good at all in any event. So the reason I mention that is that my learned friend
You mean
is
whether
asking...
the underlying claim?
Yes, absolutely.
Worried well.
Exactly, whether there was any actual cause of action for claimants who didn't actually had not suffered any loss and the like, and whether or not there was any justifiable defence to the company's position at all, or whether or not those claims would be inevitable, whether they inevitably would have succeeded. And obviously that factors into the causation question and any loss that might have been suffered. So the reason I mention that, as I say, is simply because my learned friend is asking you to proceed on an assumption, which I submit is not a reasonable or safe one, namely that the only issue that would arise in this case is the question, a very narrow question of fact as to whether or not something was disclosed and why it was disclosed. That's not the case because, albeit that is the alleged breach of duty in this claim, it doesn't mean to say that the rest of what is going on is irrelevant. On the contrary, it's very relevant to the issues that are raised on both sides in the case. Now, so
that must be right if, as you pointed out, the damages included in the damages are, well, if they'd known of the insurance position, these claims would never have been brought.
yes,
Then that must raise the question, or at least the potential question, were these valid claims in the first place?
absolutely, yes. And just, if I may, my learned friend sought to use this document, the particulars of claim, as some sort of narrowing of the assignment that had taken place. In other words, to use this document as a definition or as to what had actually been assigned, which in my submission he can't do legitimately. And indeed the assignment isn't simply of this claim, The assignment is of any claim against BLM, against counsel, or against any other person in respect of the conduct of the claim.
Well,
Now, can I
which
show
is
you?
why it's sort of rather unusually, I think,
Yes.
in the assignment, it says absolutely all claims instead of just all claims, which
Well,
say my
I will make a
master
submission on that. The word absolutely.
that.
Yes, my lady, the word absolutely is a particular word that one sees in assignments. And one sees them in assignments because not only of the provisions of Section 136 of the Law of Property Act, but also because often there are arguments about whether something is an assignment entirely without any restriction, without any charge, for example.
Right.
That's often an argument, or whether it's something else. Now that's important not only in terms of Section 136, but also in terms of possibly any arguments about champity, maintenance, and I don't know if my ladies and lords picked this up, but that was another attack that was made, which
Judge Jarman.
absolutely,
Judge Jarman did.
yeah, exactly. And the judge dealt with it in his judgment. To some extent, he was satisfied that the assignment was valid, but it's fair to say there wasn't any substantive argument, and certainly the champity point wasn't taken in these proceedings at all. And so the word absolutely is there to ensure that it's without qualification,
Yes.
and that has some resonance and importance in the light of my own friend's point that somehow subparagraph 2 limits what is being assigned in subparagraph 1. But the point, if I may, my ladies and lords, just on this on a particular claim which I draw your attention to is the definition of the assigned claims. It's under the heading background, paragraph H, we have a definition of potential defendants. As I mentioned just a few seconds ago, BLM, Mr Waite, and others who acted or advised Transform in the litigation.
I'm sorry, I don't know where you're reading from.
I'm sorry, a page in the core bundle. I'm reading from the assignment, at page
Oh,
106.
assignment, sorry, I thought you were back in your one.
I didn't actually refer you to the document first.
So
Yes.
I'm in the core bundle and I'm at,
So the assignment starts at page 115.
yes,
I'm drawing your attention to page 116, paragraph H,
yes,
the
the
definition
potential
of
defendants.
potential defendants. And then at I, the assigned claims are claims that Transform has or may have against the potential defendants for breach of contract, negligence, or other breach of duty or tort arising out of or concerning the conduct of the defence by BLM of Transform's defence in the litigation. So it is not, as my learned friend suggested, limited to this claim. It would encompass any claim that either has or may be made against any of the potential defendants as defined. And that's important in this case because at the moment, HJI do not have access to the papers. They don't know what potential other claims there might be, and they may wish to bring them. And obviously the delay in getting the papers, any of the papers to them, may have an impact on that. But at the moment they do not know, and they may want to look into the papers in order to see whether or not there are other claims in relation to other matters. This was something that I did make submissions on below, and I made the point to the judge that actually there could be all sorts of claims here, but we just don't know at the moment. That's part of what one would expect, my ladies and lords, to happen in an administration of a company. Administrators come in, they don't know exactly what's going on. They need to look at the papers in order to investigate to see. Now, in this case, they have assigned these particular rights to HJI, so primarily it'll be HJI looking to do that. But the administrators retain an interest in this, substantial interest in this litigation and indeed any other litigation, because of course they'll be the beneficiaries of any proceeds in accordance with the terms of this assignment and the declaration of trust. If I think my learned friend showed you very briefly the client agreement, essentially I don't accept the way he categorised it, which is similar to the way he did below. He sought to suggest that the claimants that were the claimants in the PIT claims would be instructing Hugh James or Hugh James Invo Legal in this claim. That's just not right. The client, the beneficiary of the rights is Hugh James Invo Legal. The client for the claim and the claimant in the claim is therefore Hugh James Invo Legal. It's not any of the claimants that were in the PIP claim.
And the recovery, or any recovery that HJ Invo Legal may make is then to be divided up in accordance with some formula.
That is absolutely right.
And
Not the
that's
formula
where
here.
That's where they come in.
That is absolutely right. And the purpose of the client agreement, my lord and ladies, is that, as one sees at page 132, and then Fred, I think, showed you some of the recitals, but actually the operative provision is at 132. What this document does is it is a document which, in return for getting something, a proportion of the proceeds of this claim, and or any other claims that might be brought, the clients give up any right to claim in the administration. So there's no double proof, in short. And what it's not just, I may respectfully suggest, it's not just the costs that are the subject of sharing under the terms of this. I mean, costs I accept. Cost is very important here. I'm not suggesting for a moment. No. It's not. But the net recoveries as defined in this agreement, they're set out, ladies and lords, at page 128. One sees that there's not just the costs, but actually it's the principle of the judgments as well. One sees that in paragraph 1, little 1. So what the claimants who enter into the client agreement will get is a proportion of their judgments together with a proportion of the common costs and so on. So that it's shared. Firstly, I'm sorry.
128 is what?
Sorry, those are the operative provisions of the Declaration of Trust. So perhaps I think I took it too quickly.
No. That's Declaration of Trust, because there are a number of different documents.
That's quite right.
So your point is that they get a share, and it's not just costs. See the Declaration of Trust.
Yes, indeed.
Yeah.
And the third bit of it is that Declaration of Trusts is a document pursuant to which HJI holds the proceeds, or the net proceeds of any litigation on trust for the beneficiaries of that trust. And they include, first, the client, the claimants who sign or enter into a client agreement. That's the one. Secondly, Hugh James, in respect of costs for those clients that don't enter into a client agreement. And thirdly, albeit it's in the second paragraph, for the company Transform itself. And so the company Transform participates, as it were, in the recoveries at two stages. The first stage is at page 117, paragraph 2 of the assignment itself. So the first entitlement is to pay, as little 1, ladies and lords, to pay the administrators the fixed amount set out below. So that's at A, 250,000 for recoveries over 250,000, so up to 5 million. And then at B, 5% of the net recoveries. And then the balance is what's called the balance of net recoveries, is the sum that's held on trust on the terms that I've just shown. So the administrators or the company will participate, first of all, in these specific sums, 250,000 and 5%. And then if and once the participating clients have had their share and the costs have been paid, then they'll get the balance as well. So that's the assignment, and that's, I think, all I need to show you just for the moment. I submit that the starting point of the Learned Friends submissions is wrong, in that what is going on here, if you like, isn't just about costs, and it's not limited to the actual claim that's actually been pursued so far, but it's actually much wider than that.
I've just noticed you having taken us to the Declaration of Trust.
Yes.
That at paragraph 10 of the Declaration, it again has reference to a wider breadth of potential claims.
Yes, absolutely. Yes. Essentially, just standing back for the moment, what is going on here is this. The administrators have been put into this company, and they're facing, at that stage, they were unable to trade. They had no money with which to trade. They were facing all this litigation, and they had to decide what best to do in the creditor's interest. And what they did was they sold the business.
Pre-pack, wasn't
Absolutely. It wasn't, I think, technically a pre-pack, but the difference probably doesn't matter in this case. But they decided to sell the business and certain assets to the main funder. And then in relation to the litigation, they just couldn't see that there was any benefit in trying to continue to oppose these claims. So they allowed the automatic stay and moratorium under the Insolvency Act to be lifted and for judgments to be entered. And that's what happened. And then once, I think a little bit of time had gone on, indeed it was after the request had been made for delivery up of the documents, and that was not successful. It was at that point that these claims were assigned, so that somebody else, if you like, would put in the cost and money and effort that would take to bring a claim such as this, rather than the administrators, who otherwise would be diminishing a return to creditors. So that's the background. If I could then go to the authorities on really what the central point in this appeal is. What I have planned to do, ladies and lords, is to take you through the authorities in chronological order, just because doing it in that way helps in my submission, just to understand where the law is and has been in my submission for a very great period of time, namely about 150 years on the authorities that I've cited to the court on this question of successor entitled principle. My learned friend has submitted in his skeleton argument that that's a sort of limited principle, or applies very specifically to the specific terms of any particular agreement. But when one looks through the authorities, one doesn't get that impression at all. This is a principle which is, in my respectful submission, very well established and has been applied in many different situations by the courts. And this sort of analysis that my learned friend has conducted doesn't actually reflect itself in any of the authorities that I've cited, albeit that there are some helpful bits of those authorities. I mean, I appreciate every case is to some extent specific to its facts, and I accept that entirely. But in terms of the principle itself, it's not limited to certain types of assets, certain types of transfers, whether it's in relation to a property, which is a common successor in title, whether it's in relation to a partnership, or whether it's in relation to an assignment of a cause of action. The principle is of wide application. It's simply whether you are the successor to the title of the previous holder. That's where I would like to start with this. Now, I don't know whether you've had a chance at all to look at the early authorities that I've cited in the skeleton argument. I wouldn't be surprised if my lords and ladies hadn't done that.
But I noticed that it's 3 minutes to 1.
Yes.
So perhaps it's sensible for you to start your analysis of the authorities after the short adjournment.
I'm grateful.
2 o'clock.